You're listening to the B&H Photography Podcast. For over 40 years, B&H has been the professional source for photography, video, audio, and more. For your favorite gear, news, and reviews, visit us at bnh.com or download the B&H app to your iPhone or Android device. Now here's your host, Alan Weitz.
Greetings and welcome to the B&H Photography Podcast. David Deal is the founder of and principal attorney at the law office of David C. Deal, PLC, located in Charlottesville, Virginia. He's also a return guest to our show, and unbeknownst to him, Jason has rebranded David as being our podcast's official in-house legal counsel. How do you like that? Add that to your resume. We even have a coffee mug with the B&H logo on it for you next time you stop by the studio. You're official. Okay. Well, all kidding aside, David is a nationally recognized intellectual property attorney specializing in copyright infringement matters on behalf of photographers and businesses, and he has successfully litigated cases of all sizes and complexities in a majority of federal jurisdictions. David has researched and written on the issues regarding the case of Vivian Myers' estate, and in our previous conversation, we focused on his recent case of Russell Brahma versus Violent Use Productions. He's going to provide us with an update on this case, and then we're going to get into a conversation about his latest case regarding the estate of rural portrait photographer Michael Disfarmer. Anyway, David, welcome back to the show. Good to have you back again.
Thank you very much.
All right. Where do we start on this one here?
I'd love to.
Are we catching up or starting something new here?
Real quick, jump back in any update on the Brammer case, and maybe I can summarize real quickly. It was a photo that was taken by a local Washington-based freelance photographer. It was used in the website for a film festival, a relatively small film festival in that area.
It was a street scene at night from a rooftop.
Scene at night, and they used it without permission, and there was some other issues regarding it, and they went all the way to court. You know, nobody wanted to settle. And David handled the case and won, and it became a pretty big case. So David, take it from there, I think.
Well, the case it was heard by the Fourth Circuit Court of Appeals. The Court of Appeals disagreed with the district court ruling on the fair use issues. So the case ended up back before the same judge, Judge Hilton, in the Eastern District of Virginia. And I would say probably a month or two out from trial, the case finally settled.
Oh, it did.
Okay. Yes. So
well, so you were responsible for the reversal of the initial decision at the appeals level, and then
right.
When we spoke to you, it still hadn't gone. It was scheduled to go to trial again, and you're saying that, of course, it's settled. So that's good.
It did.
That's good news, right?
And like a lot of things, it was a relative, in the grand scheme of things, it's a pretty simple case. It's not a case with potentially very high damages. It's a fairly modest case, but like a lot of cases that ultimately serve as legal precedent, it's not that. It's the issue. Mm-hmm. It's a specific legal issue that neither party wants to budge on, and so so either a court of appeals or a higher court has to rule on things. Mm. So that's absolutely what happened in this case.
So in this case, then it sounds like they're having settled. No decision has been made. I mean, or does the decision of the appeal court stand up as precedent?
It does. The appeals court decision is precedent, and it turned out to be, in the end, a published case, which means that informally there's a difference between a ruling by a court, whether or not it's on a motion or it's a decision on liability and damages itself. But there's a significant difference between what we call a published case or an unpublished case. A published case means that someone either at LexisNexis or Westlaw, those are the two main kind of archivists.
Right. Publishers, yeah.
Yeah. Someone at one or both of those companies deemed the issue and the case to be of some importance, and therefore worthy of being indexed in their systems. So that's what we describe as a published case. They're much easier to find. They hold informally. They hold more weight when it comes to future citations.
So it's a benchmark case, essentially, right?
It is. It is.
Gotcha.
It means something. Every case, every order, every ruling by a court has legal precedent. But published cases, again, informally, they carry more weight, and judges are more. There's no hard and fast rule, but judges are more likely to follow the guidelines of a published case rather than an unpublished case. So so in the end, while the result and the settlement was a fairly modest one, the case was well worth following through on just because of the issues that the appeals court cleared up.
That's great. I mean, that's great success.
It set a precedent then. Okay, so people can think twice before pulling the same thing, theoretically.
That's right.
So maybe I can ask you, David, then just to kind of summarize real quickly. I remember when we spoke, there was like 4 ways that where they were trying to defend the infringement.
That's right. The really great thing about the opinion is that the appeals court touched on all of the 4 elements, and they emphatically rejected the defendant's arguments on all 4 of the elements that are to be considered for fair use. So the defendant in this case had they placed emphasis on more than just one. So just to, the big picture is that the four main parts of the fair use consideration are: number one is the purpose and character of the use, and specifically whether or not the use was commercial in nature or nonprofit or for educational purposes. Just because something is used by a nonprofit for educational purposes doesn't necessarily get you a ruling of fair use, but there's a different. The courts have stated repeatedly that there is a difference between commercial nature versus educational purposes. Commercial nature is kind of leans much more against fair use, while educational purposes and use by a nonprofit weighs more heavily in favor of fair use.
And they tried to claim themselves as a nonprofit, and it was kind of shown that they weren't in this case.
No, not necessarily. In this case, they're not a nonprofit, so they didn't claim that, but they claimed that it was not commercial in use. Somehow their use on their commercial website was somehow not commercial.
Right. Okay.
That this is a million different variations of this argument, which is, we have this commercial website for our commercial business entity that is in the business of making money, but we also have this other part to our commercial website where it's just a blog, and we just, out of the goodness of our heart, we just want to be the disseminators of useful information for our clients, and therefore there's a difference between those two things, and that's exactly what this defendant was claiming, that it was informational.
They should have just paid the photographer.
That's right. That's right. Yeah. So that's element number one. Element number two is the nature of the copyrighted work, which means, was the copyrighted work a one in the case of a photograph? Was it a one-of-a-kind photograph of an event that's only happened once in the past 500 years, and the photographer that took the photograph was the only person there and the only person has the image, or was it a photograph of a manhole cover? That's the difference. So there is a difference between photographs. All images are not created equal when it comes to a determination of fair use. And this argument always really perplexes me, because the argument the defendant made in the Brammer case was, well, it's just a photograph of a street scene. Anyone can take this street scene. There's a million different versions of this same neighborhood. Well, my argument, my response to that is always, well, that might be true, but you chose my client's photograph. Mm-hmm. You chose my client's photograph because it stands out conceivably. It stands out. It's of a higher quality. It does what you want it to do. I mean, that's the whole nature of being selective of the type of visual material, photographs or otherwise, that people choose to copy. Mm-hmm. I mean,
there could even be a situation where the quality of the photograph may not even be outstanding, but the cropping of it lends itself to the final use better than any other cropping. Maybe it was the only horizontal or vertical, and it was the only one that fit the format they needed. So that's makes it unique too.
And you might be every commercial photographer that's shot for a minimal amount of time knows this. Sometimes, depending on your work, sometimes the value of your photograph is not, and the marketability of a photograph, the image you make, is not necessarily the result of careful consideration and lots of money and traveling to some exotic place. Sometimes it's just being in the right place at the right time and having a minimum level of technical ability to make a really good picture. Mm-hmm. And I think if you're not in the field, people don't understand how much skill it takes to capture a photograph quickly and without thinking about it too much. So there are lots of things that go into the second element.
And this photo was also, as we talked about in the previous episode, it was a well-made photo. It wasn't just a click.
Absolutely.
It was a long exposure. Right. It was he found the right angle, and
it worked for a very specific reason. Right. There's a reason why they wanted it.
Also, I want to mention this idea that a value of a photograph changes over time. I mean, you may take a photo in 1970 of a musician, and it's not, in demand, but 30 years later, it could be a very in-demand photo of a famous musician now,
And that it's really interesting you brought it up, because that is exactly one of the points that I made at oral argument in front of the Fourth Circuit Court of Appeals, which is the defendant's position was, it's just a photograph. It's just a photograph that has a, it was worth, and this is their argument, it was worth a minimal amount when he took it. It's never going to change. And our point was, that's not true. Any photographer, any commercial photographer that again has worked any length of time knows that exactly what you just said, which is the value of photographs changes, especially if you're a portrait photographer, and especially if you're a location photographer. A building might burn to the ground. It might be demolished to make way for something new. A person that you photographed 20 years ago might have just passed away. So the value of photographs is not fixed. It's fluid. So the other, I will hand it to the defendant's counsel in the Brammer case. I mean, they did make arguments about all four elements of fair use, and they were poor arguments from my standpoint, but they were
addressing them anyway.
They were addressing them, yeah. And the flip side of that is the danger of that, and I guess the benefit to my client, Mr. Brammer, and any other photographer plaintiff that has similar facts, is that the court addressed all four of the arguments. They were not just ruled in our favor, but emphatically ruled in our favor.
Mm-hmm. That's
is that one of the reasons why you think it became a published?
I think so. It's also an appeals case too, which just automatically garners a little bit more attention. And cases that are appealed tend to be issues that both sides feel very strongly about, and they again, very generally, that's the case because it's an issue that may not have been definitively decided prior. So it's cases that are published, I would say disproportionately are cases that are appeals cases are higher, just because there's an issue that people disagree, and everybody wants to get settled.
That's great. Well, this sounds like a great success. I mean, or at least holding up some bulwarks to changes that, let's say, the commercial enterprises around photography might have been wanting to keep in place, in the sense that, we can just use this stuff for free. And here's a little like bump in the road anyway for that idea. And let's hope it stands up.
The funny thing about the case, and I can't talk too much about it, but the funny thing about the case is, I have since the settlement in the Brammer case, I have 3 other clients with nearly identical cases against Violent Hughes, and they're being actively litigated right now. And I'm not making this up. The defendant has put forth virtually the same defenses.
Wow. And you implied, and maybe you can't talk about it, that Violent Hughes is not necessarily the organization that is pushing these cases forward. Maybe there's people behind them, law firms or others, that want to establish precedent in the other direction.
Yeah, I'm not really sure. It defies. I mean, at least from my perspective, it defies logic. Just because the alleged infringement of the 3 open cases is virtually identical to the use that Violent Hughes made of Mr. Brammer's image. Same URL, same context, same page, same purpose. Wow. So I'm a little confused as to what the defense may be this time around.
I guess we're gonna have to follow up on that too, then,
yeah,
because they just won't quit. Interesting. So can we jump over real quickly to Vivian Maier, if there's anything to update? I know that we didn't dig into it too deeply in the last episode because we were concentrated on the Brammer case, but and you may have jumped around now that you're working on the Disfarmer, but is there anything to mention to update us on that?
Yeah. The Vivian Maier case, after a number of years, is there's an end in sight, okay, which is wonderful. So the estate was opened in 2014. It's now 2020. The case has slowly but surely been moving toward the point that we almost find ourselves at now, which is, in the end, there will be a final full evidentiary hearing on the motions for heirship petitions for heirship that are currently before the probate court. So there's a lot that has taken place between 2014 and now, but in the end, the case is of a certain complexity that I think warrants what is going to happen. We are going to have a full hearing of the evidence which is quite unusual for a probate case. The case is remarkably complicated in that there are 170 individuals that play a part in the determination of heirship. And of those 170, I think there's 171. Of those 171 individuals, 9 are potential heirs. And 9, not all of them are part of the petition for a declaration of heirship.
So the idea that this hearing will kind of air everything, it's going to open all the windows and get everything out on the table. Is that the hope?
Yes.
Right.
Yes. And so we, I say this just because even the best of us, including reporters and others, sometimes make the mistake of saying, well, there's some kind of suit. There's someone sued somebody else in the estate. That's just not accurate. The only active case involving the Vivian Maier estate is the probate. Okay. And the only thing remaining for the court left to do is to determine who the heirs are, if there are any. And there are certain legal standards, evidentiary standards, that need to be met in order to prove that individuals are indeed heirs to the estate, and that's what.
Are you counsel for some of the heirs? Are you going to be counsel?
I am.
In this hearing?
Yeah. So
okay.
I'm counsel to 5 of the potential heirs.
Gotcha.
And
let's catch up on that too. When is that hearing set for?
We don't have a date for a final hearing. We have a preliminary hearing set for April 2nd of this year, at which point the probate judge is going to review our evidence. Is going to review in very superficially review what evidence we have, how many documents, who's going to attest to certain things, can they be authenticated, can they be certified. We're also going to provide them with a list of witnesses, who they are, what they're going to testify to, and so forth. So I think it's the probate's court way of performing, just because there's so much information.
Triage, right?
Yeah, it's a way the court is going to just figure out before scheduling, a week's worth of the court's time for an evidentiary hearing, just to make sure that they're, for lack of a better legal term, that we have our information in order before we schedule the final evidentiary hearing.
I think there's a road trip here.
I think so too.
It is.
Is it open to the public? Or at least the hearing?
It's public.
Okay.
Road trip.
If there's one probate case that you want to witness, I think this is going to be the one. I mean, we're going to potentially have hundreds of documents as evidence, as well as conservatively probably 12 to 15 live witnesses, including potential heirs, genealogists, other individuals, mostly all traveling in from different countries in Europe to testify about their piece of the genealogical puzzle.
Wow. So basically what you're saying is that since your first appearance on our podcast, your career has really taken off, huh?
It is never dull.
All right, so let's jump over to Michael Disfarmer, and maybe I can just do a brief introduction to the
this is an interesting case.
Yeah, so Michael Disfarmer, and I guess many people may know of him, was a rural portrait photographer in Arkansas.
Arkansas, yeah.
From the 20s through the 50s, he kind of hung a shingle in this small town and did portraits of the local folk, the farmers and the soldiers and the young girls.
Now,
and
one thing I'm curious, was he actually a working photographer? Or was this something he did as a hobby?
Yes.
No, he had a studio photographer his whole life. Yeah.
He was absolutely a professional and a very dedicated, commercially successful photographer.
Okay. And it sounds like he was a character too. Like, his name was not Disfarmer. He changed it in what people believe it as kind of a diss to the farming, this idea of being a yokel, and he wasn't crazy the way he I guess he grew up or was expected to be, and he became a bit of a bohemian. No, is that fair to say?
It's really interesting. This case, the Disfarmer case, is like anything else that there, and it happens to be the narrative that has been repeated over the years. There are similarities between the Disfarmer case and the Vivian Maier case.
Right. It's a way to kind of also marginalize a little bit, right? When you start talking about people in these ways, like they're just a maid or they're just such and such.
That's right. And it's never, and we all know it's never that simple.
Right.
And the
Alan's just a podcast host. I mean, his photography. What about him? But no, can I just jump real quick in? I'm sorry to interrupt, but I wanted to kind of finish the summary, at least as far as I know it, and then I'm going to let you run with it because, we want to do this regularly, and this is kind of meant for the audience that we're going to do a kind of hopefully returning segments as this case evolves. But, he died without any, at the time, it seemed, known heirs, and his negatives were, I guess, taken in by the local friend, a former mayor of the
3,000 glass plates.
And then I'm just going to correct you real quickly because
please.
Unlike the Vivian Maier case, there is a probate court order dividing his estate.
Okay.
So
from back then, from when he died.
That's correct.
Okay.
That's correct. And it was, in some ways, the case is a little bit easier to trace the genealogy and the potential heirship, because he had 6 brothers and sisters, all of whom were identified in the probate order, dividing his estate. So they all got 3 of them were living at the time of his death. 3 of them had passed away, but the 3 that had passed away all had children. So 1/6 of Disfarmer's estate was equally divided among the 6 siblings, and for the 3 that had already passed away, that 1/6 equally among the closest living children. Mm-hmm. Mm-hmm. So we know exactly how the estate was divided at the time. What the problems started after that.
And the problems were basically that the images, the prints and the negatives, and I guess prints were then made from these negatives, were distributed kind of into the New York art world in the 70s and 80s and sold very well. And several gallery owners and collectors, and I imagine a few other people that we're not sure about.
Notables, yeah.
Were profiting off of this. And it slipped through the cracks, is that fair to say? And now the case is, you can tell us.
There's some similarities between the 2 cases, the Vivian Maier case and the Disfarmer case, but there are also some dramatic differences. And the biggest difference in the Disfarmer case is that potentially, we still don't know, but potentially the negatives were acquired legally. Mm-hmm. But just like the Vivian Maier case, there is a fundamental and clear difference between the legal possession and ownership of negatives and prints and the copyright. Those are 2 fundamentally separate things. And like the Maier case, the individuals and the entities that were responsible for the dissemination and the let's call it marketing and the distribution of the Disfarmer images failed to acquire the copyright. Whether or not they did that purposely or out of ignorance, it doesn't really matter.
So you could own a negative, but you may not own the rights to the negative. Is that what you're saying?
The reproduction.
The reproduction rights, yes.
Yes. So physical possession of an original work is one thing. The copyright to that same work is something completely different. Usually, in the case of photographs, photography is the best example. Usually, they go hand in hand. The author of the photograph possesses, whether or not it's the digital file or a negative or a print, the author is the one, at least for the time being after the creation, is both the possessor of the actual work, digital image, print, slide, negative, and the copyright. That's the default position. Everything starts there. Now, like the Vivian Maier case, those 2 things can separate. Copyright can only be transferred and assigned by written instrument, by statute. Therefore, just because you stumble upon some negatives in an antique store or in a not paid for storage locker, or a barn or an abandoned house in the Disfarmer case, just because you might have stumbled upon something like that, and in the best case scenario, legally bought or was given or in any other way legally acquired the physical negatives or prints, copyright does not automatically come with that. That's the issue. And copyright is the right to copy, disseminate, make derivatives, basically exploit the work. Mm-hmm. And that fork or that break took place the moment that the individual who found the Disfarmer negatives after about a decade of kind of essentially abandonment. That took place when he failed to do any kind of due diligence about the copyright holder of the images, which happens to be his Mr. Disfarmer's descendants.
Right.
Would it be fair to say that this is probably one of the most misunderstood concepts of photography and ownership of photographs?
Yes, certainly. And even the best of us have a difficult time squaring those two things.
Yeah.
And it's second nature to an intellectual property attorney, and maybe even a photographer. But it's certainly not second nature to anybody else. The Disfarmer case is even more interesting because there's an issue of that's not present in the Vivian Maier case, which is it's a legitimate legal issue, which is Disfarmer was a small town portrait photographer. He had clients that literally walked in his front door, paid him to take their photograph, and walked away either probably not that same day, but probably very shortly thereafter with some prints. That is a completely different, potentially. We think we're on the right end of it, but potentially there is a legitimate legal issue as to whether a client of a portrait studio is hiring the photographer under work for hire circumstances and instead of something else. So if they're work for hire, then the copyright issue gets a little bit more gray.
Right.
Perhaps then the subject then owns the copyright?
Potentially, but and to make things even more complicated, in between the time that Disfarmer worked and created these studio portraits, and now, and more importantly, when the copyright was appropriated by a certain individual and a couple of business entities, the law changed.
Yeah.
So the copyright law of 1976 grandfathered in all work previously created before the passage of the Copyright Act. So there is a legitimate legal issue as to what type of work, in terms of copyright and copyrightability, what type of work was Disfarmer creating, and therefore where does the copyright lie?
Can I make a suggestion? Get yourself a good attorney. Seriously. This isn't easy.
So can you give us a little idea then of what we have to look forward to when we come back to you and talk to you over the months regarding this case, and like what are the next steps for you and your clients and where we're at in the stage? Yeah.
So there are, in the Disfarmer case, because of the passage of time, the work has been copied and reproduced and disseminated and sold and resold under many different circumstances. Part of our job now is taking an inventory of the last 35 years. Where his work ended up, who copied it, who sold it, under what circumstances. But fundamentally, there are a couple main actors in the Disfarmer case. Some with, from our perspective, a tremendous amount of liability, others with very, very little. And we are trying to, my office is currently in negotiations with a couple of those parties to determine what to do.
You're talking to the people. There's still the potential for a settlement and agreement and figuring this out without going to trial, right? And I'm assuming most of these are galleries and sellers of photo prints, fine art prints. Is that?
That's correct.
Yeah,
that's correct. Like anything, some potential opposing parties understand the value and the need of handling things without litigation. Others, it's the exact opposite. So we're not. It's such a complex, constantly shifting case that I'm not exactly sure where things are going to end up, but we are slowly but surely making progress toward a resolution that benefits everybody, and that's the way it should be.
Now, even though obviously the galleries and a lot of dealers would not be real happy with your point of view, how many of them are sympathetic or understand that these things have to be put into place and there are guidelines that have to be respected? Are most of them on board with this, even though they may not be happy with the fact they might have to write a check?
I believe so. what continues to surprise me is that individuals and parties that really should know better soldier on without, in my opinion, doing the work and doing the research and securing the permission that they should. So, and I'm not sure how that happens. I'm not sure how it happens. Why an experienced New York gallery that deals in copyrighted work would proceed with supervising the printing of archival negatives in limited editions and selling them to collectors without being certain of the copyright.
Right.
Good for
do you think it's fair to say, though, that in the past 50 years or so since these images came to light and were beginning to be sold, that the attitude and the ideas have changed? So it's kind of a legitimate mistake, if you want to call it that way, in the sense that there was a resurgence of finding, older work, even in music, and and putting that out to the public, and obviously they were profiting off of it. So I agree, they should have done their due diligence. But do you think there's some idea or some validity in the idea that we've come to realize this over the past 50 years more so than back then, or is that just my wishful thinking?
Well, I mean, I'm not. Yeah, it's certainly not a clear. There's certainly not an obvious answer to that, because despite on paper, someone's, whether or not it's the author's or the author's heirs or whoever, despite someone's copyright being violated, there is an overall value to disseminating very good works of art, whether or not it's music or photography or painting or anything. There is an inherent value to that. But my point would always be, all of those things can be accomplished if the would-be copier of the work and the individual or the entity that wants to display or disseminate someone's work does a little bit of work up front.
Right.
I mean, that solves the problem. It's the fundamental thing that you learn the first week of law school is that, a little bit of extra time up front,
right,
at least envisioning, contemplating what potentially could go wrong. That time, you pay for that time, times 100, because the alternative, where you just plow forward without doing that work, to reap 100 times the damages, compared to just doing a little bit of legwork and a little bit of preparation and a little bit of contingency planning. And I'm afraid that's the same dynamic, or the dynamic that a lot of these galleries and a lot of these individuals did. They for whatever reason, be it impatience or just plain rationalizing their behavior, don't do that little bit of research and planning beforehand and plow forward, and then they get themselves deeper and deeper and deeper into the situation where they can't get themselves out of.
And in general, as you indicated before, if the prints and the negatives were sold and whatever archival prints were available were then resold, we wouldn't really be having this issue. But the fact that those that got a hold of the negatives made the copies regularly and repeatedly and then started selling them, that's the heart of the issue.
Yeah, and the difference for my clients in both cases is that there's a significant amount of revenue that was generated based on the exploitation of the copyright.
Right.
It would still be an issue. Trust me. The Disfarmer family and the members of the family that I represent are in it for a multitude of reasons.
Mm-hmm. And could you say who you are representing?
I represent. There are approximately, in the Disfarmer case, we haven't nailed down the exact number, but there are approximately 85 to 90 individuals that are members of the extended family of Mr. Disfarmer, and that is closest living descendants of one of the 6 heirs or one of the 6 siblings. My office represents about 55 to 60 of those individuals.
Wow.
Nobody's going to die a zillionaire, but it's about principle, really.
No. And in a case like this, nobody is going to get rich because number one, the revenue that's been generated is some of it is not recoverable, but other. I mean, I can say without question, my clients are interested in number one, setting the record straight.
Right.
They want to make sure that Mr. Disfarmer is accurately depicted, which is kind of gone, kind of scarily off course. He's depicted as this alcoholic that was a loner and, was odd and peculiar. That's absolutely not true. I've been to Arkansas I'm working with a pair of researchers for the past 9 months, and we've made trips to Arkansas and we've talked to in person countless members of his extended family, and most of them have stories about how he used to invite them into his studio and show them how things work and play the fiddle at night. And he absolutely was not this odd figure that we think kind of adds in some weird way adds value to his work.
Sure, to the myth.
Sure.
But they're in it for a lot of very good reasons.
Great. I'm hoping we can just kind of throw out what you think we can expect over the next month or so in terms of the development of the case. I know you're still doing research and all that, but...
Yeah, and there's some boring kind of procedural issues that need to take place, but there are also some really interesting legal issues that maybe not they might not be resolved in the past month, but they're on the horizon, and they're certainly at some point going to have to be resolved, whether or not a court decide on them or negotiated by the parties. But the ones that I mentioned, number one, fundamentally, a prerequisite as of March of last year, the Supreme Court in the Fourth Estate decision held that any plaintiff who brings a suit or a cause of action for copyright infringement must have registered the work prior to initiating litigation, which means that if and when my clients are to be involved in litigating a matter and regarding any kind of potential opposing party, the work itself has to be the subject of a completed application with the United States Copyright Office. That is a difference as of March of 2019. So before anything else happens, we have to register his work, which we are in the process of doing now, which is gathering all of his work, making high enough resolution copies of all of his work, putting them in discernible groups that we can register with or apply for registration with the Copyright Office. That's the main thing that's going to be happening in the next month.
Okay. All right. So then when we come back, we'll ask you about how that's gone. I have actually a few questions maybe in the bigger picture regarding the heirs specifically, and maybe some of his about his history. But I also have this question that, let's say, for example, when this is all sorted out, and we don't have to answer it now, we maybe leave it with this as like the cliffhanger. But if let's say this all gets sorted out and future copyright monies go to the proper descendants and the proper heirs, is there the risk that the images won't be disseminated and they won't be out there as much because they're not going to be sold, they're not going to be pushed by those that can profit off of them?
I can definitively tell you that the answer is no. There is no chance that the family is going to, if they prevail, there is no chance that they're not going to make the images available to the public. That's exactly the opposite of what their desire is. Yeah. Their desire is to, they're almost to the person. They are thrilled that they're a descendant of someone like Mr. Disfarmer, right, and are incredibly proud of the work and have exactly the opposite of what you just described, in that they want to make sure that.
Will they have the means though, and the distribution networks and the connections and things like that. I mean, obviously his work is established and it's out there in museums and everyone knows about it, but it's just one of those questions that maybe is the flip side of when things aren't in the hands necessarily of commercial vendors. They often get put in the shadows.
And my short answer, yes. If my clients prevail, they will have the means to make the work available and to have the work continue, to be available to the public.
Maybe even in a better way.
Yeah.
David, thank you again. Fascinating discussion. Photography is more than cameras and lenses and megapixels for sure. If people want to catch up to what you do on a website, where can they go?
My commercial website is my first and last name. So it is daviddeal.com.
Okay. There you go. Fascinating stuff, an interesting niche of the legal profession that affects all of us here that were listening to the show. And we look forward to having you back and, getting some updates on things. Thanks again, David.
Thank you very much, Alan and John.
Okay.
Thanks, Dave.
Okay, that's our show. Now it's time to go. Are you not a regular subscriber to our podcast? All you have to do is head on over to Apple Podcast, Google Podcast, Stitcher, Overcast, or Spotify and sign up. It's a freebie. It won't cost you a dime. And you could always find this on the B&H Explorer website, as well as the B&H Photography Podcast Facebook group. My name is Alan Weitz. Some things never change. And on behalf of John Harris and Jason Tables, thank you so much for tuning in today.